right. So I'm going to pass it to Clarice to start us off and let all of our attendees know how they can engage.
Hi, everyone. My name is Clarice Robinson. I am the manager of EXiT, Executives Transforming Probation and Parole, a network convened at the Columbia Justice Lab. EXiT consists of 90 current and former chief probation and parole officers with the goal to make probation and parole smaller, less punitive, and more hopeful. Before we get started, I just want to highlight one quick feature. If you look at the bottom of your webinar, you'll see a Q&A function. Please use that in the latter part of today's webinar to pose any questions that you have. Thank you again for joining us. Kendra, I'll turn it over to you.
Great, thanks. Thank you, Clarice, and thank you to all of our attendees and panelists. We have one panelist who's still working on getting in, but we'll go through introductions in the meantime, and hopefully he's able to join us soon. I'm Kendra Bradner, Director of the Probation and Parole Reform Project at the Columbia Justice Lab. And I'll just briefly introduce our wonderful panelists, and we're very grateful to have you with us today. So Sandra Johnson is the in-prison coordinator with Root and Rebound, but she's joining us today in her capacity as a board member for the East Bay Community Legal Center. And that organization is one of two conveners of Debt-Free Justice California, a coalition that led the charge for AB 1869. Sandra is originally from Monterey, California, and draws from her own personal experience coming from a single-parent household and having several formerly incarcerated loved ones. Her oldest brother is currently 31 years into a 17 to life sentence. She's formerly incarcerated herself, having served 15 years in and out of the system. Sandra is an advocate for other families with incarcerated loved ones and has served as an expert witness providing testimony before the California State Legislature and the San Francisco Board of Supervisors. Her testimony and organizing was instrumental to passing the Fair Chance Act and the RISE Act in 2017. Thanks so much for being with us, Sandra. Next, we have Michael Mendoza, who's Director of National Advocacy at the Anti-Recidivism Coalition. 22 years ago in Southern California, Michael made what he calls the worst decision of his life, agreeing to participate in a gang-related murder. At 15, Michael was sentenced to adult prison in an era in which the prospect of release was under 5%. The message was clear. The state determined he was not worth helping, and he would spend the rest of his life in prison. He eventually rejected that perspective, turned his life around, and focused on education and becoming the person he wanted to be. California Senate Bill 260 gave Michael the opportunity to prove he deserved release, and after 17 years, he was paroled in 2014. Well acquainted with the power of policy to reform our broken prison system and provide hope to the many more currently incarcerated, Michael immediately began working on criminal justice reform, testifying and advocating for key changes to law. Michael has worked as a case manager at the Center for Juvenile and Criminal Justice, obtained a BA in political science, and served as national director at Cut 50 before returning to the Anti-Recidivism Coalition in his current role. Thanks for joining us, Michael. Brendan Woods, appointed in December 2012, is the first Black chief public defender in Alameda County's history, and is currently the only Black chief public defender in the state of California. Brendan has 20 years of experience in criminal defense litigation and leads 170 staff in providing superior legal defense in more than 3,000 new files monthly. He is committed to providing holistic representation to his clients and is a nationally recognized leader in public defense. He's a board member and former president of the California Public Defenders Association, and was honored with the Harvard Law School Wasserstein Public Interest Fellowship for outstanding public service. From a young age, Brendan had formative experiences with law enforcement, steering his life and career toward public defense. He feels fortunate to fight for those battling systems of oppression and strives to reshape the discourse and nature of public defense and criminal justice as a whole. And finally, thanks for joining us, Brendan. And finally, David Mohammed is Executive Director of the National Institute for Criminal Justice Reform, a steering committee member for EXiT, Executives Transforming Probation and Parole, and a senior advisor with the Justice Lab. David is also former Chief Probation Officer for Alameda County, California, and is a leader in the fields of criminal justice, violence prevention, and youth development. Through NICJR, David serves as lead consultant and technical assistance provider to the Sierra Health Foundation's Positive Youth Justice Initiative, supporting probation departments through the state of California to transform their juvenile justice practice. David also provides leadership and technical assistance to the ceasefire violence reduction strategy in the cities of Oakland and Stockton, California. And he is a consultant and technical assistance provider to Cities United, a national initiative to drastically reduce homicide rates among Black men in American cities. And David, thanks so much for joining us. I know you're dealing with internet issues, but so if you have to go off camera, that's fine, but great to have you with us in the conversation. All right, so just
thank you.
Just a reminder to attendees who have joined us since we started talking, please use the Q&A function in the bottom to submit a question at any time, and we'll make sure to save time for those at the end. All right, so let's dive into questions. I'm really looking forward to our conversation today. Brendan, I'm going to start with you. So let's talk about AB 1950, which shortens the maximum probation term for felonies to 2 years and for misdemeanors to 1 year. Can you tell us a little bit about the significance of this bill for California and for supervision reform more broadly?
And I'm not sure, first off, thank you for having me. I'm really honored to be on this panel with these great people here, and it's good to see some familiar faces. So first off, I'm not sure I'm going to be able to really capture the significance of this bill and what it does. The impact it'll have on people's lives of the state of California is tremendous. So for example, in Alameda County, when I started as a young public defender, many eons, years ago, centuries ago, it was standard for felony probation to be 5 years. For almost every case, 5 years. So when you think about that, people who went through the criminal, I don't call it justice system, criminal legal system in Alameda County always came out with a 5-year probation tail for almost every felony. I don't know about you, but having that sort of weight on a person for 5 years, I cannot describe how that must have felt. And to have this law change that to 2 years for most felonies is tremendous, just tremendous. Think about the fines and fees associated with the constant contact with probation, with the constant force of authority hanging over your head, whether it be through search conditions or payment of fines or check-ins, just the ability to work and have a job, having that removed or reduced to 2 years is absolutely tremendous. And I could go into more detail, but one thing that's important that maybe people should really understand, it's not like this law just eliminates probation completely or it applies to all cases. Now, there are some exceptions within that. So for example, on the misdemeanors, and maybe people don't notice, misdemeanor probation normally was 3 years probation. Now it's going to be 1 for most cases, unless that particular crime in the penal code describes that charge to have a prescribed term of probation, whether it be 3 years or 4 years. For example, a misdemeanor child abuse is always 4 years probation, or a DUI is 3 years probation. So it doesn't reduce terms for all cases, but most. And that same thing carries over for felony probation. It won't be 2 years for all cases. It'll be 2 years for most. It excludes violent felonies and a lot of DV, domestic violence cases, and those that have prescribed probationary terms for that particular charge in the statute. But I want to give David a chance to talk also, but I can't really begin to describe the impact this will have on people's lives.
Thanks so much, Brendan. So David, I'll go to you. I wonder if you have anything to add to that, but also I know that AB 1950 was accompanied by a shortening of parole terms in the budget side. So can you talk just a little bit about that, and also a bit about why shorter supervision terms are needed in addition? Damn, we just lost David. He'll join in a minute, but okay. So in the meantime,
He might still be there. Just there he is.
There you go.
Sorry about that, folks.
I think you're glitching a bit. It might be better
So yeah, a
without
couple.
the video.
Yes, and let me know if you can hear me. I can go off video if it's easier.
It's definitely better without video,
Got
unfortunately.
it. Okay. So I think one, I want to appreciate Brenda did a great job describing the bill, and I think did the appropriate amount of appreciation of this is huge. In terms of the number of people it will affect, it probably has the largest impact of any of the criminal justice reform bills that we've seen in this state, and because the size of California, probably in the country. And so there are, more than 300,000 people on probation in California.
We lost you, David. Okay.
And sorry for the interruption. I'm hoping you can hear me.
Now we can. Go ahead.
Yes. So we're talking about nearly, at one time, 1 million people impacted between misdemeanor probation and felony probation. But obviously, it's going to be numerous, millions over years. And it's all about the science and the research. The science says that people will generally commit a new offense or violate the terms of their probation within the first 18 months. A lot of research backing that up, and that there's little evidence showing the effectiveness of probation supervision, certainly beyond 2 years. And so this bill really looked at the science, applied it, as well as the significant cost savings to counties and the state. And across the board, some last minute amendments taken to have those exceptions that Brenda mentioned to the violent felony cases, but the vast majority of misdemeanor cases will be 1 year, and the vast majority of adult will be 2 years. And it has a very wide impact, both in terms of improvement to people's lives following the research, a reduction in jails and prisons because of less violations, and really follows a series of pieces of legislation in California in the past 3 to 4 years that have really gone to make significant reforms in the system in California.
Thanks so much, David. So let's turn to you, Sandra, and talk about AB 1869. So that bill eliminated 23 administrative fees, many of which are administered on the county level, and including several that are currently imposed on people on probation and parole. It also writes off all of the existing criminal fee debt, which sums to over 16 billion. Can you talk a little bit about why eliminating supervision fees is so important, not just in California, but in justice reform more broadly?
Well, being on probation and parole is already stressful enough. Then when you have all this extra pressure on having to pay money that you might not have in the first place, that's another extra stressor. The way I feel about it is it's a real big hardship, because when I was on probation, I was on parole because I wasn't on probation long. When I was on parole, I had I was already trying to, get my life together, find a job. You don't get out of incarceration and get a job like that. You got all kind of pressures. I was looking for a job. I was in a short program. I was on a program. I had stressed on that my time out there was gonna run out. So to have these extra fines and fees is just another stressor to me. I was excited when they were eliminated, because it impacted such a large amount of people, and I love anything that helps a large amount of people. And and I was also excited because it helped people that was impacted by the system, that already had a whole bunch of other stuff to worry about, trying to get their life together. So yeah.
That's great. Yeah, really taking away some of those additional barriers. Thanks, Sandra.
Mhm.
So Michael, let's talk last but certainly not least about AB 2342. So this one, it passed the legislature, but then was vetoed by the governor. It would have allowed for people to earn additional time off of their supervision period by completing specified milestones like education, training, treatment programs, volunteer service. And we know that the earned time credits are a critical piece of the puzzle. Can you talk a little bit about why that is and why it's so important?
Yes, definitely. And thank you for that question. And thank you for having me on board to discuss the importance of this bill, even though the governor didn't sign it. And although the governor didn't sign it, I would have to say that the journey of this bill has been a success. And it has to go back to 2017 while I was on lifetime parole myself. And after 3 years, just thinking to myself, there had to be a better way. And fortunately, at that time, I was surrounded by a lot of amazing and smart individuals like David Mohammed, Brendan Woods, and others who really took this idea and the intent of this bill and introduced it in 2018 into the legislature. And we're really talking about a time when we talk about parole, we weren't talking about it the same way we were talking about it now, where we have the governor who is going to cap parole next year. And we're also looking at CDCR implementing this idea of implementing a credit earning opportunity for people on parole, which has been critically important even within the last 2 years of discussing that. And the reason I say that is because, in California on parole, we have over 50,000 people every single year on average on parole in California. And most, and about over 7,000 of those people are on lifetime parole. And I was on lifetime parole. And to what Sandra was saying, and what parole is meant to be, there were a lot of hard conversations that we were having just to try to pass this bill. And as you've seen, it's been difficult since then. I remember going to the first year in 2018 when we couldn't get it past the assembly floor, simply because DAs, district attorneys asked me to exclude people with life parole and people with violent offenses. And that was a move we weren't willing to make and concede on. And so knowing how important this issue was in the last 3 years has been critical to defend why everyone on parole should receive these opportunities and not exclude anyone. On top of adding to that, now we have people who can vote that are on parole right now, which makes this topic even more important when we're looking at defining what reentry should look like. It should be a time of supportive reentry and not punishment. And so when we look at the intent of this bill and what it aimed to do in the last 3 years, it's been a key in trying to shift parole to being goal-oriented and not time-based. As mentioned, my friend Brendan Woods mentioned earlier that the weight of a felony for 5 years is completely a struggle for people on parole. And so to shorten these lengths of period of time for people on probation and parole is really what the intent of these legislative efforts have been to do. And the fact that we had a lot of formerly incarcerated people who were on parole themselves, some for a lifetime, and sharing their stories in the last several years has been a critical and necessary push to, first and foremost, change the narrative. And so when we look at AB 2342, when we look at the earlier versions that had the same intent, which was to include everyone on parole and not exclude anyone, it's been a success in this journey to be able to have the governor really cap parole terms now in 2021, and looking forward to how we can reform the parole and probation system even further in the years to come.
Thanks so much, Michael. So I want to, you all have brought up so much amazing stuff already, but I want to dive a little bit deeper into the impact. Brendan, you talked a lot about the impact on people's lives who are under supervision. I wonder if you could also talk a little bit from your perspective as a public defender, why is shortening supervision terms important from the perspective of your staff, from the perspective of someone who does the day-to-day work that you do?
Sure, and then I'm going to just back up a little bit if I can. because there's been a little bit of a journey for me on this particular subject as it relates to probation terms. So back in actually 2007, I began to approach this when I was supervising our summer interns. And I began to ask them to do a statewide comparison of probation terms to see where Alameda County compared. And we did it almost every year and did a really more comprehensive study in 2014. And in 2014, we learned that out of the 58 counties, there were only 8 counties that had kind of a mandatory 5-year felony probation, and we were one of them. And you think of Alameda County, you know, quote unquote liberal, the East Bay, it was absolutely shocking. And so we began to talk to the DA, engage probation, and we were able to get some concessions, but there wasn't a complete movement until 2018, when the DA's office agreed, probation agreed. We had a new probation chief who really pushed it, and we got it through. But one of the biggest oppositions after that was the court and the judges. They did not want to go along with it. And the reason they don't want to go along with it, did not want to do it, was because when we think about probation and these systems, it was all about control. It was all about controlling people, controlling workload, and controlling the criminal docket. So going back way before I was a public defender here in Alameda County, the rumor mill is that they went to this 5-year probation term. It was an idea of a judge who said, we need to control our criminal calendar. So the way it works, what people don't understand often is that when you are on probation, your right to a trial pretty much eviscerates. It is gone. And the reason is because when you're on probation, the standard for a probation violation is probable cause, and it's up to a judge to determine whether you violated your probable cause. So the way it plays out is if you are on probation for, say, 4 years, 5 years, whatever, and you're in year 3, and you get arrested for a new case, whether it be because the police targeted you, or you were in the wrong car, or the wrong house, could be something completely out of your control, and you could be innocent. You could take that new case to trial, get acquitted by a jury, because beyond the reason without, they could find you not guilty. But that judge who determined your probation violation could say, you know what, I think there may have been a crime here. I find you in violation, and send you to prison like that, just like that. So when it comes to our practice, having someone be on probation is really devastating, because it takes away that ability to really prove their person's innocent on their trial. And so what happens is this vicious cycle of people taking plea bargains and then getting a longer probation tail. So day to day, in some ways, when someone's on probation, it can be demoralizing for the attorney representing them and for that client, because they know, even though, God darn it, I could be innocent of this case, because of that probation tail, the chances of the government, the prosecutor, and the state having more control over me is absolutely devastating. And so for us, this bill really is tremendous, because it gives power back to us as litigators. It gives power back to our clients as they are trying to defend their cases. So, I mean, really, it really is mind-blowing and shifting the sense of power. And, you know, I'm a big thinker. Okay, I try to think of big things. I didn't think of this. I mean, I did not think of this. I can't get credit for this. This came from community thinking about how to improve their lives. And thank God for community advocates. I mean, really, this is amazing. I've gone on a long time. So as far as a practice standpoint, having the ability to be able to defend someone on a new case because they're not on a 5-year probation is tremendous. Being able to tell a client for a low-level misdemeanor, no, you'll be on probation for a year, and then after that, guess what? You'll have a better chance of getting a job. Or you're on probation for 2 years, you'll be able to get a job. Those things matter. They're really, really significant. So that's how it'll apply in our practice, and that's how it's going to impact our clients.
That's really helpful, Brendan. Thank you. David, I want to go to you, and a similar question. You know, can you talk as someone who's run probation systems, what the difference is before and after AB 1950 in terms of how probation and parole officers do their jobs?
Yes, and again, I'm hoping you can hear me. So the I want to say a couple of things. Brendan made a good point, and it's funny. I remember in 2011, we took his and his interns' charts on the probation terms and turned that into the first draft legislation to reduce probation terms. That version was down to 3 years because Alameda County had 5 at that time. And that's when I was specifically told by the district attorney that they use those terms to bring violations in new cases instead of bring the new offenses for the higher standard of, of evidence. And so this is a huge victory and really revealed a huge challenge. I do also want to make sure that folks know. I know somebody asked about why did the governor or why did the governor veto the legislation that Michael spoke of, and I'm sure there's numerous reasons, but one was the other thing we haven't talked about in depth yet is that the governor did, through the budget process, reduce the terms of parole down to 2 years, which is another huge victory. So we really secured some significant victories around community corrections. But in terms of operating probation department, this is actually also huge for probation officers. It really reduces their caseloads, reduces their workload, and allows them to do much better work with the people on their caseload. It really should be about them engaging and providing services, supports, and opportunities to the folks who need it, and building on the strengths of the folks that they work with. And they can't do that with crazy caseloads of 60 to 1, 71, 100 to 1. So this really helps the workload out of probation officers throughout the state.
Great, thanks, David. Sandra, I want to go to you. You know, from your perspective as someone who's experienced supervision, who's experienced paying these fines and fees, why is eliminating supervision fees important, and what sort of difference will AB 1869 make in the day-to-day life of people on probation and parole?
Well, because so many people are living below poverty levels before they go to prison. It really only makes people poor with paying these fines and fees once they are released. And it also forces them to choose between paying for, you know, spending money on essentials like paying rent or for their family, you know, paying for their essential and caring for themselves and their family. As a matter of fact, fines and fees, you know, only makes being on supervision worse for me. It was for me. And maybe being on supervision, you know, also as extra punishment. I mean, you know, having these fines and fees at extra punishment after you are released from incarceration. And it doesn't allow people to save for, you know, like a safety net or something, you know. It just really takes away from the whole household, from the family, just from a person that is already has a lot of stressors. It's just too much. I think these fines and fees are ridiculous. And sometimes when people come out of incarceration and they used to have these fines and fees, because I know a lot of them been eliminated, they were discouraging. They were so huge that people couldn't even wrap their brains around even paying this. They didn't even know how they were going to begin to pay it, or if they were ever going to get it all paid off. So yeah, that's how I feel. I'm not big wind, but I love listening to you guys talk. But for me, fines and fees was huge. It was a huge stressor, because what I had to do was I had to you know, get my life together. Then I had to work my fines and fees into my bills. You know, it was like a bill where I didn't even have money to pay my normal bill. So, but it made me think, if I didn't pay, it had me living kind of in fear. Like, if I don't pay this bill that I have here for my fines and fees for my probation, then there was a chance of me being, put back into custody. So it was always like hanging over a big weight. And Brandon had said something that brought me back. Although, of course, I've been on probation for a long time, but it was a huge burden, being on parole with these fines and fees. And I'm sure that it was a huge burden being on parole for such a long time too. So, I really worked really hard to get off parole early. I did everything that, that was my goal, to get off parole early. And in order for me to get off of parole at an earlier time than 3 years, it was required that I have all my fees paid. So it took away a lot. It took away from my life a lot. The things that I really needed, I had to I had to figure out how to juggle stuff just, to get these fees paid and to get off parole, because I didn't like supervision. Because and I don't know if I should say that probation and parole officers are not always nice. They put a bunch of like stuff on you. I know it's a lot of laws and it's a lot of coalitions and help now, but back then I was just trying to get out from under someone's thumb, and I had to pay those fees off in order to do that. So that's it.
Thanks, Sandra. I think that's a really important perspective. So Michael, I want to go to you. Can you talk a little bit about how, the shortened terms, and both you and David have talked about how, although AB 2342 didn't pass in law, a lot of progress has been made in spirit through these other pathways. Can you talk a little bit about how that will play out on the ground, both for people under supervision and for advocates who are thinking about kind of your next step in moving reform forward?
Yeah, when we talk about the impact or the day-to-day of what this bill would intend to do and what we're hoping California does moving forward, and going back to what David mentioned earlier, through the budget, the governor is going to cap parole, which, to the question, is part of the reason why the bill was vetoed. But the other part of that, when we look at it, is he also mentioned that the California Department of Corrections and Rehabilitation is going to take that next step in implementing the intent of AB 2342 through regulations. And so California has decided to implement this day-to-day measures of a credit earning system for people on parole through regulations, which could be easier to change in the future versus going back to the legislature. So that's one. And when we look at that avenue, what we then have to do next is ensure that CDCR implements the majority of what this bill intended to do. And what that would look like, on the day-to-day is, one, with the decrease in parole terms. We also need to make sure that CDCR shifts this system to be more supportive for the people on parole rather than the parole system itself. And what I mean by that is, when you have individuals who are coming home, are volunteering their time, are going to school, whether it's for an AA degree, a bachelor's degree, or even a high school diploma, we need to incentivize these folks to recognize the work that they are doing to move above and beyond their parole requirements. And it's important that we get this right and that we have CDCR set this up right, because what we want to do and move towards doing is hopefully eventually be able to say, when somebody successfully discharges parole, they should automatically be eligible to apply for a certificate of rehabilitation. But not just that, we should also strengthen what a certificate of rehabilitation does for someone who successfully discharges parole, which could lead to looking at certification and licensing and other restoration of rights that people should earn once they successfully not only complete their prison term, but once they successfully discharge from parole. And that's what we eventually want to get to when we look at the implementation of this bill and the day-to-day matters of it.
Thanks, Michael. Before I move on to my next question for the group, Brendan, I want to go back to one thing that you said about this lower standard of proof that exists for people who are on supervision. One thing that folks outside of California or even inside California may or may not know about misdemeanor probation in California is that it's typically unsupervised. I think I have that right. Which, folks can look at and if you're not familiar with what the experience of being under supervision is like, might think, well, that's really nothing, right? Why do you need to shorten it if it's if they're unsupervised, if there aren't conditions on them? But I think where it really does make an impact in people's lives is that that lower standard of proof. So I wonder if you could talk specifically about just how this plays out for people who are convicted of misdemeanors in California and what that looks like on the unsupervised side.
Sure, and I want to add to that, even though for misdemeanor court probation, you're technically unsupervised, you're on supervision to the court. And often, I'd say probably 90% of the time on misdemeanor court probation, you do have a search clause. And that is probably one of the most intrusive aspects of probation. There's three-way search clause and four-way search clause. Most often a four-way search clause. Things search you, your house, your car, your property at any time.
I'd say 95% of the time, Brendan.
95%? Okay, there we go. And that's a huge impact. So you get stopped with your family, they can search you. They can come to your house, they can search you. They don't need a reason. That is almost license for unlimited harassment by police officers. That's what it does. So even though it's quote unquote unsupervised, it still has a tremendous impact on your life. Part two to that is the ability to get a job. There's some places that ban the box, you can't ask questions, but still any employer has the ability to look, research, and find out if you're on probation. And so those are things that really impact you, even though you don't have the regular supervision. You have to check in daily with a probation officer. And I guess the way it does play out in practice is the same way as for felonies, where if you are on misdemeanor probation and you are able to come in contact for a technical violation or even a new case, the burden of proof is so low, the likelihood of you being incarcerated is very high. And then you almost, in some ways, can't defend that unless you have an airtight, solid case, an alibi from the Pope to prove you didn't do what they said you did. Okay, it's almost that high of a burden. You need the Pope or Obama or someone to come in and say he didn't do it. Okay, but it's that sort of thing. So even though you're not, quote unquote, checking in with a probation officer, it's still this onerous burden that you have on you every single day that you have to live with.
Thanks, Brendan. I appreciate you going into that for folks who may not be familiar with how that plays out. So this next question I want to pose to the whole group of you. So you should feel free to chime in and respond to each other and build on each other's responses here. We talked a little bit in our preparatory call about how California has had a steady drumbeat of reform bills around the criminal legal system. And California has certainly made some significant strides. You guys have large coalitions of advocates on the ground, and policymakers have been conditioned to care about these issues. That's not true everywhere. So what can our audience do to change that where they are, if it's not true where they are? And what are some of the things you think are, keys to passing similar initiatives in other states or other jurisdictions?
Well, I guess I'll go first. Am I muted? No.
You're good. Go ahead.
So we have made a lot of strive in justice reform. And what I think California did was that they allowed system impacted people to lead that work. And so being system impacted myself and being able to speak in my own voice to committees and committees that was empowered to passing these laws, it allowed me to feel like I was part of the solution from these issues that was very traumatizing for me and the communities I came from. So that's how I feel. I think California did a great job at allowing people that with lived experience to, you know, pick up and go up there and speak, you know.
Yeah, you know, if
Yeah.
go ahead, David.
And this, oh. Go ahead, Michael.
I'll be quick, Dave. I just wanted to follow up on what Sandra was saying, because I think it's really important and critically to understand when we look at California, you know, going back 6 years ago, in 2014, when we had one of our first big wins in passing Senate Bill 260. And since 2014, we've seen a lot of formerly incarcerated people come home and like Sandra, go to the Capitol and tell their stories and change hearts and minds. And, you know, specifically when we talk about probation and parole and trying to change that system, what I would recommend to other states, aside from centering impacted people, as Sandra was suggesting, in front of a diverse coalition of many experts, but also to learn how to talk about the issue and learn how to talk about the people that are impacted by the issue, I think is critically important. You know, was it just a couple of years ago where we were still talking about people as parolees, offenders, criminals. And today we're using a different type of language that I think is really important in how we engage the legislature in their learning process on how we talk about these issues. So I would recommend that we learn how to talk about these issues in every different state in a humanizing way, but that we also collaborate, communicate, and combine efforts, not just within states, but from state to state on what best practices are on how to move these issues forward. And so I just wanted to add that on top of what Sandra really hit the point on how we center the voice of impacted individuals in this work that we do.
Thanks, Michael. David, go ahead. I know you wanted to chime in.
Hope you all can hear me now. I want to, you know, Michael, I think
we're losing you, David. I think you're going in and out.
Yeah, I said her internet and jump in later.
Okay.
While David's upping his internet, I'm going to take a chance to say something here. And I agree with everything that's been said. It should be community driven, but I'm also going to take a little bit more of a cynical approach too, because power doesn't concede power, right? What do these people listen to? So I think if you are advocating in a place that is more conservative, and you're trying to create change there are two things that move people, okay? Money and results. So I might be cynical, but I think money and results is what moves people. I go back and I question and think about realignment, AB 109, how we got that going here. And I think it was about money, right? That's what they wanted to save money at the state level. I think some people in those positions of power care much more about how they're spending their dollars than they do about people. So if you can present an argument to them that shows how they can be fiscally responsible and also get good results on criminal justice reform, then you have action. But I do think it comes down to money often, and I hate to say that. When we think about this right here, AB 1850, what it does is it can save a tremendous amount of money for states and counties. It does. And then that money can be reinvested to provide better supervision for smaller amounts. So, you know, think about California, I believe, spends about $2 billion each year to incarcerate people for technical supervision violations. $2 billion. That's insane. We spend about $235 million to incarcerate people for victimless technical violations, so like coming home late or missing curfew or not reporting your address. That is an insane amount of money. So when you present that to legislators, they go, "Oh, that's insane. We should not be spending that much money on that sort of stuff," and they listen to that. And then when we think about results, I mentioned earlier about how Alameda County did the 5-year probation term, and that was a way of control. It was not based in any way, shape, or form on what would be evidence-based, what would guarantee results, what would be better for the people we serve, what would be better for probation. It was not based in any way, shape, or form on that. So bringing forward studies that show that shorter probation terms will actually benefit people on probation and create better outcomes is what needs to be done. They listen to that sort of stuff. I am a skeptic, and I think there are those people in those positions that sometimes don't really get the people piece of it. They still have the mindset that people who commit crimes are like criminals and inmates and prisoners, and they don't get past that. So if you can give them a different dialogue, at least to get your foot in the door, and then bring people like Michael and Sandra until they get the people connection, then you can create that change. That's my cynical outlook on that.
While David's getting back in, Michael, Sandra, do either of you want to build on that or have other points?
Yeah, I think while David comes back in, and please, David, feel free to interrupt when you come back in. Would love to hear from you further. I think when we think about next steps, I've been home for 6 years now. I just got off of lifetime parole last year, and I still can't apply for a certificate of rehabilitation in California. After I've completed my prison term, after I've successfully discharged, I still can't apply. I'm just talking about applying. And I think that needs to be changed. I think we need to learn and look at how we not only move towards shortening the lengths of probation and parole terms, improving the resources for people to participate in as they re-enter, and even lessening the burden of fines and fees. Aside from that, I think it's really important that we set people up to succeed as soon as they immediately discharge, and get their lives back together and be able to lead towards licensing and certification and jobs people with felony convictions normally can't get for an old felony conviction. And so I really see an opportunity to continue to change the system in a way that continues to build on the person's life once they've exited the criminal justice system. So I would really love to see more research and study on certificate of rehabilitation and how we can improve on that for people who are on probation and parole.
Thanks, Michael. And that flows right into the final question that I'll ask before we go to some of these questions from the audience. I'm watching them in the Q&A, and we've got some good ones ahead of us. So that final question, the bills that we've talked about do a lot, but they certainly don't do everything that needs to be done in supervision reform, as you just alluded to, Michael. To the full panel, what are some of the ideas that you'd like to see advance next, either in California or more broadly, and why is that?
Okay, so myself, I would like to see ankle monitors to be eliminated. I have friends myself that had to wear them, and they were not only hindering, they were constantly malfunctioning. They were, I know that fines and fees for them to pay for them was eliminated, but they still cause problems. Like one time I was with my friend and we went in there and someone was like, "What's that on his ankle?" And he had to explain. It embarrassed them. So I think that the ankle monitors, I would like to see eliminated. That is one thing moving forward, I think is, should be gone, because my friend would have to get up in the middle of the night. The parole officer was calling them, like if he got in the shower and got wet, it was just like terrible. It was like excruciating. And I used to feel so sorry. I was like, oh my God, I'd be so glad when you get that thing off, because it was, again, another unnecessary stressor, especially for someone that was working and doing the right thing. And, if the went off, they had to go and call, they had to be, questioned, like, what did you do? It was always, what did you do? What are you doing to it? And it was like, I'm not doing nothing to it. It just went off. Like, so I would love to see the ankle monitors moving forward be eliminated. That's
Thanks, Sandra. Brendan, Michael?
You want to go, Michael? I got a list.
Go for it. Go for it.
Okay. Thanks. So I was thinking about this, and as it pertains to the bill I talked about, number one, eliminate incarceration for technical violations. I can't tell you how often we would see people picked up on a bench warrant for failure to update their address to probation. That is insane. Okay? Insane. So if you think about, okay, someone forgot to update their address, doing great, they have a job, whatever, they didn't do it. So we arrest them on a warrant, we bring them into custody. It costs $190 a day to incarcerate them, while that person loses their job, loses their house, loses everything else. It's absolutely insane to incarcerate people for technical violations. Okay. Number two, add some sort of speedy trial rights to probation violations. Currently, there isn't that right to have a probation violation within a certain period of time if you get arrested and violated. So there's a kind of elusive right to have it within a reasonable time, but not like a hard, you have to have your hearing within 60 days or 45 days, the same way it is for trial. I think that number three, the burden to be found in violation should be raised higher than probable cause. It should be clear and convincing, or if you want to make it be more aggressive, make it beyond a reasonable doubt. But it's got to be higher than probable cause, because I find my kids in violation of probable cause all the time. That's not the violation or standard you want to have in a criminal proceeding. And finally, I'm going to keep going. We talked about those categories that are excluded from 1850. God, I think is 1850?
It's 1950. But
1950. Thank you. God, I had a number off. I remember what it was. Thank you. From 1950, there should be some way to get those excluded categories credits to have their probation terminated early. I hate the way we continually in criminal justice reform put the others in different categories, meaning those who are convicted of violent offenses and serious offenses. They're always put in other categories, and we have to stop doing that. And finally, going back to something I want to see changed nationally is the fee issue. I don't think people realize how significant the fee is, and I'm going to talk about it from my perspective as the public defender. So we always hear people, on TV, you get rid of your Miranda rights, right? You have the right to remain silent, and they say can it be against you, blah, blah, blah. If you can't afford an attorney, want to be appointed to you. Sometimes that damn attorney can be expensive as hell, okay? Those fines and fees ran up very, very quickly. We got rid of fines and fees for a public defender's office here, I think it was about 2 years ago now, which is great. But in some places, those fines can be onerous. And there could be up to $350 for a first appearance, and they build on top of that, $450 for a litigated hearing, and they just keep climbing and climbing and climbing. So we talk about those Miranda warnings and providing counsel if people can't afford it. We should be providing counsel. So if the government and the state is going to cage people, incarcerate people, prosecute people, put them on control, they need to also defend those same people. They need to put up the same money to make sure that they aren't incarcerated falsely or they aren't convicted falsely. So if you're going to spend billions on billions of dollars in incarceration, you have to defend them also and not do it on the backs of poor people, making them pay for the defense. So I'm sorry, I got fired up there. So
no, that's great, Brendan.
Okay.
I want to go to David while he has a brief moment of solid internet.
I don't know about solid, but internet. So one, I love when Brendan gets fired up. So I want to, a couple of things. One is, California is ahead of many places, right? So there's places in Louisiana and other parts that they're raising money for public defense and perverse incentives within the jail fees. It's ridiculous when you can get a public defender. In other places that have private probation. I worked on a case in Tennessee with private probation where it was all misdemeanors. So they had a whole private probation system for people convicted of misdemeanors that had built into their policies incentives to violate people and get more fines and fees. It is horrific. And places like Georgia that puts everybody moving on probation, literally speeding tickets you get placed on probation for. And so it is, we have a lot of work to do. And some of those places are places that have made progress. I mean, Georgia has made some reforms, have made some changes. So in terms of California next steps, I want to say two things. Build on what Brendan said and said we really should eliminate incarceration as a result of a technical violation, right? People should not be incarcerated for technical violations. Second, and I think there was some of this in the question and answer of the chat, that we really need to move. So yes, a major victory is reducing the time people spend on probation. We need to now move probation to actually be helpful and supportive and positive. Now, there are many POs I know in California who are like that, but that's the luck of the draw of the PO. And it's not county by county, as somebody told me before. It's cubicle by cubicle. So I think I'm losing my stable internet connection. But so the last thing is to make policies. This might be difficult to make a law, but to make policies that the job of the probation officer is to connect the person on their caseload to the services and supports and opportunities that they need and to build on their strengths. That should be their job. That should be their job description. That should be what they're held accountable to, and not just hand them referral slips, but to ensure there is a connection to service and supports. And again, there's POs right now who do that, and they're wonderful, but it's not all POs, it's not, unfortunately, most POs, and it's not what the requirements are of the job. We need to move it to become the requirements of the job.
Thanks, David. Michael, anything else you want to get in on that?
No, I think that was well said on every front. So I'm looking forward to see if there's any other questions that we can answer. It takes some time.
Is that Brendan guy again?
Brendan.
Yeah, David, you actually raised a good point. I have a question now. Can I ask a question?
I'll use moderator's privilege to grant you first question.
Thank you. And this is something I don't know why I didn't think of earlier. Probation is, I guess, technically, maybe not, but I think technically an arm or an extension of law enforcement. We should change that, right? I mean, why should probation come under law enforcement? I want to get your thoughts on that, David. Should it be housed somewhere else?
Yep.
Okay.
Yeah. So I have some schizophrenia over this, but I'll give you the two. One thought is, do we shrink probation just for the small number of people who have some genuine high riskness, and then keep it under law enforcement? Although it doesn't need to be even for that, so I'm all for it. The second part of that is, I think LA is turning into an example on the juvenile side. So there's a proposal right now before the Board of Supervisors in LA to remove the juvenile division of the probation department out of probation and make it a non-law enforcement agency. So we're seeing that now, and we have precedent of that in other places around the country. But I think that's right? In terms of when we step back and say, what is the purpose? We want somebody to not commit another offense. We want somebody to be able to have improvements in their life. There's not a lot of evidence that law enforcement gets those outcomes, right? And so if you look at it in those terms, then it makes a lot of sense to say, okay, if the entity that's going to provide support and connection. I try to use connection versus supervision. That probably shouldn't be a law enforcement. And so that is a huge piece. And I think we're going to see the beginnings of that in California out of Los Angeles on the juvenile side.
Great. So I'm going to turn it over to Clarice, who's going to be our gracious moderator of the Q&A. I can see we've already got a lot of really great questions running in, so we'll try to get to as many as possible. Go ahead, Clarice.
Thanks, Kendra. So I'll start off with some questions about conditions and caseloads. One of our first questions says, are there any plans to reduce the number of probation conditions? I'm glad the length of probation was reduced, but we need to look at the number of court conditions. Do any of our panelists have response to?
And can I just quickly say, I saw that was raised by one of our esteemed colleagues, Chief Probation Officer in San Diego. So great point. If you add that to another former Chief Probation Officer's question in Santa Cruz, this notion, what I just tried to address in terms of making it better and more supportive, there's probably no adult who could withstand the level of conditions that we have on probation. The numerous conditions that any which violation could result back into your incarceration. And so a big thing we need to do is reduce the number of conditions. There's a few states, Kendra probably knows this a little bit better than me, but there are a few states who started to do this work to really reduce the state required number of conditions of probation. And that's absolutely an area where we're deficient in California, where we need to take someone else's lead of reducing probation to just a few conditions.
Thank you, David. Would anyone else like to add on? Okay, our next question. Was there anything in the bills that helped shift practice for officers, aside from lowering caseloads? Also, I've read that this would help people on probation access services, but are there budget provisions that shift resources?
And just another quick answer. So no, what I'm assuming you're referring to was an early version of the governor's budget, where there was going to be some budget work to improve services and have a focus on improving outcomes. That didn't go forward. Because of the COVID budget crunch. But that part also had a pretty horrible component to it, which was increasing misdemeanor to get supervised by POs. But it also had this good component, which was more money for services. But what 1950 just limited the time on probation, and what I mentioned earlier about we got to change policy to actually improve the work and make it the requirement that you're connecting folks to community-based services.
Okay, thank you. I'm just looking through. Another attendee says, I've never heard of a certificate of rehabilitation. What would it take to get this through the governor's office? Michael, would you like to answer that question?
Yeah, so currently, depending on the conviction, some people have to wait at minimum 7 years, some 5 years, just to be able to apply to a certificate of rehabilitation, which basically is just a court order saying that you have been rehabilitated. And so when we look at the certificate of rehabilitation and now moving towards shorter probation and parole lengths, it just doesn't make sense to keep this length of a certificate of rehabilitation at such longer periods for people to wait just to get that recognition. So yeah, I think what's going to be needed, obviously my colleague Sandra, who is currently applying for a certificate of rehabilitation, and many others need to continue to apply, including myself, when I'm able to. But in the meantime, we just need to do more research on how many certificate of rehabilitations have been granted, who have been granted these certificate of rehabilitations, and to what extent have they been helpful when we talk about licensing and certification and those sorts of things. And if they haven't done much for people who have earned these certificates, then we need to strengthen them and what they actually do for people who achieve them in a meaningful way. And so there's still a lot of research to be done. something that I'm grateful that the Anti-Recidivism Coalition is looking into.
This is Brendan. Can I add to that? I think Michael's raised some good points, and I'm thinking about this now. I'm assuming it'd have to be a legislative fix, and it's something we should definitely be looking at, but also making sure that, or maybe do some study to make sure implementation is done equally or evenly amongst all counties, because it's not done that way. There are some places that it's harder to get one than others. There's more opposition from certain prosecutor offices than others, and there are more requirements. So maybe reducing the terms and making sure that it's done at a level or equitable playing field, as opposed to some places being very strict and very harsh and not moving anything forward, and having been more lenient in other places.
Thank you. Our next question says, supervision fees also fund valuable services for individuals under supervision. Example, treatment, urinalysis. Did the legislature increase funding lines or streams to replace services that were funded by supervision fees? Would you like me to repeat?
I think the answer to that is no.
Right. I thought I saw Brendan responding because it's my chick internet. No, the answer is no. And the fee, the fees were county by county, were allowed to, so there were many to the state elimination. The state didn't eliminate all fees.
I think we're losing you, but Brendan, did you want to chime in on that one, or should we move on?
I was trying to make sure I got the tail end of the question. I'm not sure I got it, because I think it's maybe twofold, and David can maybe chime in. I don't believe there were any funds associated with AB 1950, but I thought there were funds associated with AB 1869. And I can't recall off the top of my head the amount, but I thought it went into effect in July, and I want to say 70 million. That's down right in that range. I just can't recall right now.
I'd have to look, but yeah. Okay, so we can look into that one.
Yeah. The short version is no new money, but
that's the best answer you ever gave, David.
Yeah. I think I heard no new money, but perhaps realignment. So we'll come back to that, or David, maybe you can put it in the chat. Clarice, back to you.
What community groups are working on probation reform, changing outcomes to improve support and connection? Do any coalitions exist on this issue? And that's for any of the panelists.
Yeah, I can speak to part of that. I mean, at least, within the last 3 years, personally, within my own capacity at several organizations, including Cut 50 and the Anti-Recidivism Coalition, we've had our eye on parole reform. Now, nationally, we have another amazing organization, the Reform Alliance, focusing on probation and parole nationally and in other states. But there are also a lot of great organizations in California, like Root and Rebound, where Sandra is working at and working on these issues. We have other amazing organizations like Young Women's Freedom Center, Initiate Justice, and just so many others that work on these issues together as a part of a coalition that we can definitely connect folks to, not only in California and other states, to look at how we have looked at this from a coalition perspective. But there are some great organizations working on this on a state level and national level.
Does California utilize private probation services? If so, is this being addressed?
I wish I had David. I think the answer is generally no. Brendan, do you know?
Yeah, I'm not aware of any private.
Yeah,
probation
there's
services that
no-
are used. Go, David.
Yeah, so there's not private probation the way we know private probation, like in Tennessee and others. But probation departments sometimes contract with private providers of or phone reporting, and obviously with electronic monitoring. So there's not.
Okay, I think we got most of that.
Anyone on the panel, let's say that the budget of the probation budget was $100, and right now 90% of it, $90, was spent on officers and administration. What should the budget look like to focus on the safest, most effective practice?
Anyone want to chime in on that one? I think to a certain extent, David talked about that earlier, the fostering connections and making sure that it's, you know, time and energy is spent on support rather than surveillance. Others have thoughts on that?
A lot of thoughts, but I would just say we might need to change that percentage in terms of a budget geared more towards the people on parole, and especially looking at the resources within the community that people on parole need to successfully reenter. You know, I've heard several questions that are geared towards, you know, how do we resource, you know, probation and parole offices and officers? You know, to that end, we've done that for decades, for many, many years. And, you know, in California, we have a close to 46% recidivism rate. We're looking at a system that sends close to 25,000 people just on parole. I'm talking about just parole back to prisons. And, you know, we're still okay in trying to resource that system that's a failure. And so I think the other question to ask is, how do we support more of the people who are going through probation and parole and the resources that they need to succeed, rather than how do we continue to fund and support the system itself? And so I would like to kind of challenge how we look at that distribution of resources moving forward.
Thanks, Michael.
And this is,
Oh, go ahead. I'm sorry, Brendan.
no, real quickly, I think it's not a particularly easy question to ask. I think services are provided based on what that individual needs. And I agree with Michael, there's got to be that 90-10% discussion. There's got to be more towards services. But you know, research clearly shows that services that are given, whether it be mental health or drug treatment, are more effective during their early stages of probation than as it goes on longer. That's one of the reasons why I think 1950 is so important, because it shortens that term probation. Hopefully you can get services done immediately, and people can go on to have improvements in their lives. And if I can make a plug for one thing,
Sure.
That was good about AB 2342 is the incentives around education. That's a critical piece with regards to people reoffending and being rehabilitated, because we know that the stats are pretty much amazing when it comes to showing the recidivism rates for people who are in custody and they get either a GED or vocational or AA or bachelor's degree. I think the recidivism rate for people who are released from prison and they get their BA in prison is around like 5%. If they get their master's, it's like 0%. So education is such a powerful tool when it comes to people not reoffending. And we think about the amount of money we spend on incarceration as opposed to education. It's crazy, it's insane.
So I want to chime in. David is texting me with his unstable internet connection, but he desperately wanted to respond to Erica's question. So I'm just going to say a brief text statement from David. You know, a point he wanted to make about Erica Pruitt's question in the chat about AB 109, criminal justice realignment in California provided significant funds to the counties. And while many counties use it to just fund sheriffs and probation, Alameda County gives half every year to community-based services that do go through an evaluation. So that's half of 38 million, so nearly 28 million a year in community-based services, as one example of what Michael was talking about in shifting funds directly to communities.
Thanks, Kendra. Sandra, can a person on probation or parole be violated for not paying these fines and fees? You're on mute.
I've been off of parole probation for a long time now. I really don't know that answer because I didn't investigate that answer, or I didn't look that up. But back when I was on probation, I think that what I wanted to do was get off parole. So I needed to pay those fees because I was told that that my probation couldn't be shortened if I didn't pay those fees. So I don't know that answer. Does anybody else?
Yes, this is Brendan. So your probation can technically be violated for failure to pay restitution or fines and fees. It comes down to whether you have the ability to pay, whether they can hold you or not. So we often get situations where we're showing that our clients can't pay, or this is the minimum amount they can pay, and then they pay that. Then you get into the issue at the back end of whether your probation can be terminated or not, or can you be relieved from probation, or is it extended? And I think this depends on what county you're in with regards to how that is treated. So I think the more flexible, liberal your county is, the more lenient they are, and they might allow the probation to be terminated, maybe unsuccessfully or successfully, without fines being paid. But they can be an issue, a big issue in some places. And I know that when I first started out in our office, it was a huge issue for a lot of people. There's like a restitution calendar. People have to come in every few months, so they're making these minimal payments, and this onerous burden because you're coming in to show you're paying and then you're missing work. So it's this horrible cycle.
And I just want to add one thing to that. Across the country, there's a wide variety of practices around punishments for failure to pay fines and fees directly. But the other thing that we see very often is that people will stumble into other violations of their supervision because of fear of not paying, right? So they might not be able to pay to attend a class, and so that they're charged to go to. And so then they might get violated for not attending the class, even if the reason for not attending the class was because they couldn't afford it. Similarly with drug testing, maybe people are required to pay for routine drug testing or urinalysis. If someone can't pay, they might avoid it. If someone is afraid they can't pay, they might avoid meeting with their supervision officer. And so then it becomes this cascading, it can, depending on the policies and in the places and how that's communicated to people under supervision, it can become a really cascading series of repercussions that is rooted in poverty, but shows up in other ways.
Thanks, Kendra, for adding that. How much discretion does the parole board in California have? And have there been efforts to reform the process and policies for granting parole?
So when we're talking about the Board of Parole hearings, is that question geared towards specifically, obviously, for people on parole in the community supervision, correct? Because they deal with discharging people from parole who are currently incarcerated, as well as people who are on community supervision. And I would say they're one of the biggest decision makers in deciding who is discharged from parole, along with what the parole officers will submit on your behalf. And so right now in California, specifically for parole, BPH is specifically in charge with deciding who's discharged or not. And their decision carries a lot of weight. I don't know if that answers the question or what we're specifically looking for there.
Thanks, Michael.
I'm going to add something to that, something I've been thinking about for a while. Thinking about the composition of the parole board, and as a goal out there, way out there, changing that composition, and it would be valuable, or maybe revolutionary, groundbreaking, to have someone who has lived experience, someone who was formerly incarcerated, someone who has been to prison on the parole board. That's something I think really is worth considering and having. So, yeah,
Thank you. I'm just still looking to see if we've gotten any new questions.
You kind of add to that just a little bit more. Sorry.
Right.
Because if you have these people who essentially sit in judgment of other people, and they have no lived experience in regards to what that person has done, what that person has gone through, the barriers they've overcome to get to that place. And so you have people who have no experience, and they're making these tremendous evaluations that impact these people's lives. And, in the criminal system, we have this idea of a jury of your peers, which really doesn't exist, but we strive for that jury of your peers. There should be something similar in the parole situation also, where there's some sort of evaluation where we are striving to have that determination done by your peers.
Great, thank you. Oh, go ahead, Michael.
No, I just saw a question that's on this topic, what is lifetime parole? And, just to explain really quickly, at the time of your sentence, and for me, this was back in 1996, not only did a judge sentence me to a life sentence, but the judge also said, if you come home, if you're able to get out of a life sentence, then you'll be placed on lifetime parole. And technically, this is governed through California regulations, which says that if you are placed on lifetime parole, if you were convicted of a first-degree murder, you have to wait 7 years before you are eligible to appear before the BPH or the board to see if you are eligible to discharge. And if you are not ready to be discharged after 7 years, then California can keep you on parole for the rest of your life. Obviously, there'll be reviews after the 7th year. And for people with second-degree murder, it's after 5 years. And so it's exactly that. It's lifetime parole. After a certain amount of years, you are eligible. But the state of California can keep you on parole for up to the rest of your life if that was the way things played out.
Great, thank you. There's a question that says, can we address these issues in South Carolina or other states, southern states? The fines and fees don't go to assisting one with rehabilitation. So they're wondering if you can talk a little bit about how to address these issues in more conservative areas. Brendan looks like he wants to answer that question.
No, I'm sorry. My first terrible answer, like move, but that's not a good answer. So, and I've lived in South Carolina, so I know. Yeah, way back when. I think it goes back to what I said earlier about the arguments you make. And in conservative jurisdictions, they do care a lot about money and results, and making those be the centerpiece of your initial arguments. And then I think if you can get their attention and then bring in people with a lived experience, then that can move them. I hope that's somewhat helpful.
Yeah, and just on the fines and fees piece, it's an area that's notoriously difficult to research because there's a lot of hidden costs associated with collecting fines and fees, from court appearances to incarceration to just staff time spent trying to collect fees. But in a small handful of places that have really undergone an extensive cost analysis, places end up spending more money to collect fines and fees than or breaking even, maybe, in a lot of cases. And so, to Brendan's point about fiscal conservatives, that's certainly something that everywhere should be concerned with.
All right. It says, how do we get POs, probation officers, parole officers, to shift from more of an enforcement role to a social worker role?
I think, unfortunately, David would be the best person to talk about this, but I also want to build off of Amir's question about tailoring the standard conditions to each individual as opposed to, sort of blanket conditions. One thing that we said at the top, but that is bears mentioning again, this webinar is coordinated by EXiT. EXIT's as Clarice talked about, an association of 90 current and former probation and parole chiefs. They've all signed on to a statement. That statement has 12 policy aims that all of those folks have vouched for, essentially. And one of the policy aims is limiting conditions, tailoring them to only things that are relevant to that person, because conditions can be quite onerous and are a pathway back to incarceration through technical violations. I think we've talked a little bit about how to do that shift. I think it takes leadership. I think it takes change in expectation. I think it takes changing what we measure about these systems. But that's just my 2 cents. I don't know if other people want to weigh in on that.
Okay, we're getting close to time, I believe, so I'll ask a few more and then we'll wrap up. It sounds as though most of the panel members are advocating for the diminishment of probation and parole programs for various different financial and social issues rather than reforms. I know you have mentioned investment into various other different social behavior and educational programming, but how do you replace the accountability element for the safety of the communities? What would you replace those programs with?
Sandra, anybody want to go? If not, I can take a crack at this.
Go for it, Michael.
Yeah, well, great question. I just saw this Gallup poll come out today, really talk about how nationally more Americans want to see resources poured into the community rather than tough on crime punishment laws. It just came out today. I don't know if folks want to look at it. And it's interesting because it's a shift in the polls that we've seen nationally, going from, I think, a majority of, 82% of Americans in 1992 wanted tougher on crime laws then. And now we have about half of that are now saying the same thing. So there's been a huge shift in where Americans really want these resources to be placed, and that is in the community. And so I bring that up because to this question, I think the majority of the resources that people on parole need are those opportunities like education, therapeutic services to help people with post-traumatic stress disorder. And then, just a lot of other educational tools that only a community can provide, such as life skills, how to use a cell phone, how to establish a checkbook. And when we talk about, then who are the key players to hold people on parole accountable, it becomes the community themselves. I remember going to San Francisco State University through Project Rebound, an amazing program that is offered to formerly incarcerated students. And it was at this university where I was held accountable by my peers. I was held accountable by the professors. But because I was incentivized to do these things and to improve my life, I think the more we double down on the opportunities that communities can provide, then the communities themselves become the people that hold these individuals accountable to successfully re-enter and succeed, because we all then become, we all prioritize in this investment, right? And so I think naturally we'll see many people in the community that are providing these resources for people on parole naturally take that responsibility to hold these people accountable as they are reentering back into our communities.
Thanks, Michael. I know we didn't get to answer everyone's questions. A few people also put really helpful statements in the chat and the Q&A, so I hope folks get a chance to look there. We're at time, so I just want to say a huge thank you to our panelists. Thank you so much for sharing your time and your expertise with us. I also want to share, a thank you to all of you who attended. I really appreciate you taking the time to learn about this. You can learn more about EXiT and some of the work that these folks are trying to do at our website, exitprobationparole.org. We ask that you please fill out the survey that will be emailed to you tomorrow. We really value your feedback and want to know how we can continue sharing information that's helpful to move things forward. And I hope you will join us for future events. So thank you again to all of our panelists. Thanks to our attendees. And I really appreciate you joining us.
Thank you.
Have a good night, everyone.